She's underemployed. She ultimately left the marriage for another individual, but she is not going without her. She needs alimony, or she's used the term spouse support. That's really what this is she wants spouse support, but she has a boyfriend, so there's an issue. She doesn't want to go there. She clearly has an ability to earn more than $24,000 a year. She's choosing not to work, and she has her children part-time. That shouldn't be my client's issue at the end of the day.
Good morning. This is the matter of Avalos versus Avalos, case number 2502383DM. Both parties are present along with their respective attorneys. Attorney Curlis on behalf of the plaintiff and Attorney Krupp on behalf of the defendant. We are here on the plaintiff's motion for child support, communication, and parenting time exchange location. And I have read both the motion and the response. Ms. Curlis.
Yes, Your Honor. I have also read Mr. Krupp's response. And regarding the parenting time exchange and the communication, there is currently a PPO entered between both of these parties that was signed in May 9th of this year, where Mrs. Avalos was the petitioner. And I think that it would be reasonable to place in a temporary order that the parenting time exchange be at the Kentwood Fire Department on Eastern for the children to exchange the 50-50 parenting time schedule. And also the parties have been doing that. There was only one time that Mr. Avalos showed at the plaintiff's new residence, which could be a violation of the PPO, but we're not going to go there. So they have been actively using the Kentwood Fire Department as an exchange location, and they have also been using app close. So we would just like that placed in amended temporary order, specifically because of the PPO. Regarding the child support issue, Mrs. Avalos left the marital home on March 28th, and then she moved into her parents' house. Any kind of change in circumstance that would be required here, if there is any, was that she now has moved into her own housing as of June 26th, which has created, obviously, bills for her. So since she moved out in March, there has been no financial contribution towards the minor children by Mr. Avalos at all. Mrs. Avalos does earn $26,000 a year. Mr. Avalos earns $114,000 a year. The child support guidelines that I attached to my motion stated that she earned $36,000. However, I just did receive an updated pay stub, which I did forward to Mr. Krupp, that indicates $26,000. Regardless, we believe that some type of financial assistance and child support should be placed in temporary order for some temporary child support to help these kids. I did notice that in Mr. Krupp's response that Mr. Avalos states that he has some daycare expenses, but I'm not sure why he would have those when we have a 16-year-old, a 13-year-old, and a 5-year-old. We know of maybe one occasion that a teenager came over to play with Oliver, the 5-year-old, but no other daycare to our knowledge, and that wasn't attached to his response. Regarding payment of extracurriculars and other types of bills, currently Mr. Avalos is refusing to pay for Ethan's glasses, which is $375 a month. He has paid for an optional
I'm sorry, did you say a month?
Yeah.
I'm sorry, a month. That's incorrect. $375 period.
I was going to say, that's a lot of eyeglasses.
Okay.
Yeah, that's a lot of eyeglasses. I agree. So there's nothing currently entered to help these parties figure out how are we going to pay for medical? How are we going to pay for all these other expenses? And frankly, right now, Mrs. Avalos is selling her plasma just to buy groceries. So she needs some kind of assistance temporarily until we can get into a settlement conference or a final, decision in this matter.
Sure. My client's currently in the marital home. He's covering a bunch of bills. We're trying to work through ultimately a settlement at the end of the day. She's underemployed, and what was not disclosed, she ultimately left the marriage for another individual. That's her choice. That's fine. But she is not going without her, she's been living at her parents' home. I have no idea whether she moved or not. That really, when you look at it, when we negotiated the temporary order, there was a reason why we negotiated. There really hasn't been any change in circumstances. Now it's like, now we're going to change the temporary order. Well, my client's also covering a bunch of household bills. So when we did the temporary order, we thought, okay, this is fair. I think this slip was exactly what Ms. Curlis said, which was what, she needs alimony, or she's used the term spouse support. That's really what this is she wants spouse support at the end of the day, but she has a boyfriend. So there's an issue. She doesn't want to go there. In my opinion, there hasn't been any change in circumstances to modify the temporary order. Ultimately, we're going to have to do some math at the final judgment. She clearly has an ability to earn more than $24,000 a year. When they plugged in $36,000, that's probably a realistic number for her as of right now, but not 24. She's choosing not to work, and she has her children part-time. That shouldn't be my client's issue at the end of the day. The income that was stated by Ms. Grillis is correct. I asked my client what his current income is. That is correct. We don't think there's been a change in circumstances to warrant a modification. In the judgment, obviously, it's going to look different. That, whatever the guidelines are, they are. But at this point, I don't think there's been a change in circumstances. We negotiated the temporary order as is, and that's where we're at.
Okay. Ms. Curlis, what about his point that Mr. Avalos is paying a lot of the bills?
It's my understanding that he is paying for the mortgage and the utilities at the marital home where he currently resides. Now, Mrs. Avalos is now paying for her own monthly payments where she's currently residing and the utilities there as well. So they're living separately like they have been. But the difference is that she moved from her parents' house where she didn't have those expenses, and now she's into her own housing with the minor children when she has them 50%. So that is where it comes into the change in circumstance, where now she is having to pay to live on her own, like Mr. Avalos is, and needs some assistance based on the disparity of the incomes. She does have a full-time position at Kentwood Public Schools, and she does work 35 hours a week. She just got done with summer school. Her pay will increase. So for the final judgment, I would, definitely agree to send it to front of the court. But for purposes of this temporary motion, temporary order, I would suggest, maybe using the proposed guidelines. Mr. Krupp mentioned that that's probably more realistic, and we would have no problem with that. But she does need some kind of financial assistance to help because of the disparity of the incomes.
And I'm sorry, Ms. Curlis, you mentioned that Mr. Krupp had provided proposed guidelines. I don't get it.
I did it. No, I did attach to my motion.
You did. I know. I saw that.
Yes.
I misunderstood what you said. So, okay.
Yeah.
All right.
And that number was $36,000 a year.
It looks like it's 32.
32.
853.
Correct. And then what she's currently making is less than that. But my point is that 32 is probably more realistic for the future. So we're asking that the $612 per month be temporarily entered until we can come up with a final judgment.
Well, it sounds like there are some factual questions here, and since this is temporary and can be modified retroactively in the final judgment, I'll order child support in the amount of $500 per month. And again, that can be retroactively modified up or down depending on what the proofs show for the parties. And I will just say for the record that 35 hours a week is considered full-time under the Michigan Child Support formula. As far as the exchange location, I'm sorry, Mr. Krupp, did you want to respond to that?
No, Your Honor. I mean, it's more of just the logistics of having to drag a bunch of children over to the fire department is kind of a little bit of a headache, but I don't think my client has a huge issue with it.
All right. I just think given the PPO and all of that,
they have been using app close already, so
it's helpful to have some parameters around that. As far as the exchange location, I will grant the motion to have the exchange at the fire department, at least for now. Again, this is temporary. And the court does have a template that it uses for our family wizard. It could be adapted for app close that puts some parameters around when responses are expected, how bills are supposed to be provided, and all of that. And if counsel would like Ms. Van Miller to provide you with that and you can tweak it to suit this case, that might be a good idea. And that'll give you something in writing so everybody understands, like I said, what the parameters are, what the rules are, what's expected.
Okay.
Anything further?
A start date for this court is August. So
I would request the date of our motion, June 26th or July 1st.
July 1st. And again, this is all modifiable retroactively once we get some more facts.
thank you, Your Honor.
All right. Thank you.